A very warm welcome from the Bahrain Chamber of Commerce and Industry, and thank you for joining us this morning in this webinar, which will shed light on trade secrets. This webinar is organized jointly by the Bahrain Chamber of Commerce and Industry with the Ministry of Industry, Commerce and Tourism and the World Intellectual Property Organization, with the purpose of raising awareness of the business community on relevant laws and legislations such as Law Number 7 of 2003 on trade secrets. I'm very honored to be with you today. My name is Aisha, and I'm a member of the media team of the Chamber, and I'll be moderating today's session. With me here today is my colleague, Mr. Mohammed Silais. He's a legal researcher from the Legal Affairs Department of the Chamber. Joining us virtually from the Ministry of Industry, Commerce and Tourism is Ms. Shada Sharif. She's the Chief of Trademark. And from WIPO, Ms. Aida Holotbeva, Ms. Nina Belbel, and Mr. Waleed Abdul Nasser, and Ms. Tomoko Miyamoto. I hope I'm saying the names correctly. And also we have Solicitor Emmanuel Goje, who will be speaking with us today. I thank you all for being with us today. And before we kickstart, let me share with you today's agenda. Today, we will commence with a welcome address by my colleague, Mr. Mohammed Silais, followed by another welcome address by Shada Sharif, and then a welcome address by Mr. Waleed Abdul Nasser. And then we will move to today's main topics. We have four main topics, namely an introduction to the trade secret system, and then followed by a practical approach on how to protect and manage trade secrets of your business. And then the third topic will be shedding light on misappropriation of trade secrets. The fourth topic will discuss actions to be taken by business owners in the case of trade secrets misappropriation. And then we will conclude with a case study. If you wish to raise a question, you can type it in the chat box or click on the raise hand button, and the questions will be addressed at the end of each topic. Please be informed that this webinar, it has interpretation. So interpretation to Arabic is available. If you wish to hear it in Arabic, you can click on the interpretation button. And it's also broadcasted on the Chamber's YouTube channel. Now, I thank you once again for being with us today. And without further ado, I leave you with a word from my colleague, Mr. Mohammed Silais. Mohammed.
السلام عليكم. السيدات والسادة أعضاء غرفة التجارة وصناعة البحرين، السيدات والسادة المشاركين في هذا اللقاء الافتراضي، السلام عليكم ورحمة الله وبركاته. تنفيذاً لدور غرفة البحرين في تعريف أعضائها الكرام بالقوانين ذات الصلة بالتجارة والصناعة، وفي إطار دور إدارة الشؤون القانونية بالغرفة في عقد لقاءات تشاورية وتوعوية لأعضائها حول القوانين والتشريعات التي تمس القطاع الخاص حسب ما ورد في خطة الغرفة لعام 2021. فإنني أرحب بكم في هذا اللقاء التعريفي الذي يعقد اليوم بالتعاون بين غرفة البحرين وكل من وزارة الصناعة والتجارة والسياحة والمنظمة العالمية للملكية الفكرية الوايبو حول قانون الأسرار التجارية الصادر بالقانون رقم 7 لسنة 2003 وتعديلاته، وذلك لتعريف القطاع الخاص بالمواد الواردة في هذا القانون الهام الذي يمس القطاعات التجارية والصناعية بالمملكة. وشكرا.
Yes, thank you, Mohammed. And now over to you, Ms. Shada Sharif.
Yes, Your Excellencies, distinguished representatives, ladies and gentlemen, good morning. On behalf of Mrs. Rana Al-Ahmed, Acting Director of Foreign Trade and Industrial Intellectual Property Directorate, it is my great pleasure and honor to greet you and extend my deepest thanks and appreciation for attending the Trade Secret Workshop, which is organized by the World Intellectual Property Organization in cooperation with the Directorate of Foreign Trade and Intellectual Property at the Ministry of Industry, Commerce and Tourism in the Kingdom of Bahrain, supported by the Bahrain Chamber of Commerce and Industry. Thanks are also extended to the Minister of Industry, Commerce and Tourism for his keenness to activate the framework of cooperation between the Ministry and the Bahrain Chamber. I would like to express my most sincere thanks and gratitude to Dr. Waleed Abdul Nasser, the Director of Division for Arab Countries, Regional and National Development Sector, for sparing no effort to providing all kinds of assistance and cooperation to the Kingdom of Bahrain, and for his significant effort which have been made in the intellectual property field. Moreover, we would like to thank Mr. Abdullah Saad, Acting Chief Executive Officer of Bahrain Chamber and the organizer of the Bahrain Chamber for their effective contribution in supporting and implementing the workshop. As you are aware about the topic of this workshop in the trade secrets and how to protect and manage a trade secret for businesses, therefore, our objectives are to learn and share knowledge with you all in this industrial property sector. We also look forward through this workshop to achieve the desired goals to spread awareness of the importance of intellectual property rights, such as trade secret, which would serve the beloved Kingdom of Bahrain. In conclusion, I hope this workshop will bring new insight to our work and help us gain more knowledge. I wish you all fruitful discussions, and I look forward to further cooperation, hopefully face to face and in better circumstances. Thank you.
Thank you, Ms. Shada, for the very warm address. And now I will leave the floor to Mr. Waleed Abdul Nasser. Would you like to say something, Mr. Waleed?
Good morning, ladies and gentlemen. Thank you, Ms. Aisha. I would like to thank very much Ms. Shada Sharif for her kind words and for her welcoming remarks. I'd like also to thank Mr. Mohammed Al-Salesi for his opening remarks. Well, it's a great pleasure for me to be among you today. We have been working together with the Bahraini authorities, particularly the Directorate of Foreign Trade and IP at the Ministry of Industry, Commerce and Tourism in Bahrain on a number of cooperation activities and projects. And I'm very glad to have this session as one of a series of long history of cooperation between WIPO and Bahrain. I would like to thank very much through Ms. Shada, Ms. Rana Al-Ahmad, the Acting Director of Foreign Trade and IP, the Ministry of Industry, Commerce and Tourism, the Kingdom of Bahrain, for her cooperation and for the organization of this important session today. I would equally like to send my greetings to Mr. Abdullah Saad, the Acting Chief Executive Officer of the Bahrain Chamber of Commerce and Industry, for the Chamber's cooperation organizing this event. This is a good incident for us because in the new directions of WIPO under the leadership of Director General Mr. Darren Tang, there has been an emphasis on reaching out for new stakeholders and new partners in the process of building cooperation and partnership between WIPO and different stakeholders all over the world. I think this is the first time we have this joint event with the Bahrain Chamber of Commerce and Industry, and I hope we would have some sort of sustained relationship with the Chamber, as we did a couple of days ago with another Arab country, Chamber of Commerce in another Arab country. I think this is important because in the coming period, in the coming 5 years, the emphasis of the WIPO will be on the economic impact of IP, and therefore there will be more emphasis on SMEs, on startups, and on innovation incubators. In addition, I would like to extend my sincere thanks to my colleagues in WIPO. First of all, Ms. Tomoko Miyamoto, who is the head of the section for patent law and treaties, as well as I think she will be addressing the meeting at the closing session today. I would like also to thank my colleague, Ms. Aida Dolobayeva, the Senior Legal Officer at the section, as well as Ms. Nina Belbel, the Associate Legal Officer at the section. I would like also to express my appreciation for the participation of Mr. Emmanuel Gouget, the Avocat à la Cour from France. I would like to thank from the Division for Arab Countries, Mr. Mahmoud Muntasser, who is the counselor dealing with cooperation between WIPO and the Kingdom of Bahrain, as well as with Ms. Saad Shatou, the administrative support for the division, and all colleagues who have been involved in the preparation and organization of this session. I'm sure that the subject matter of this session about trade secret is a vital one for the parties concerned, for all participants today. And I hope that it will be an added value for all of them, and that it will be also an interactive session that would be mutually beneficial for WIPO, for the Directorate of Foreign Trade and IP, as well as for the Bahrain Chamber of Commerce and Industry. I wish you all success in your session today, and thank you very much for giving me the floor.
Thank you, Mr. Waleed. Thank you for exerting your keenness on joining efforts with the Bahrain Chamber. We look forward for very fruitful cooperation between the Bahrain Chamber and the WIPO. Now, we will kickstart with the first topic of today. So I would like to welcome Ms. Aida Dolot-Beva, I hope I'm saying this right, to give us an introduction on trade secret system.
Hi, thank you for introducing me.
Hi.
You can just call me Aida. I know my surname is a bit complicated.
Sure.
So let me try. I'm going to share my presentation. Just a second. Do you see my presentation now? Hello?
Yes, we can see it.
Yes, we could see it, Aida.
Just okay. Everything's okay, right?
Yes.
Okay. Welcome everybody to a national workshop on trade secrets. We're happy to see you here. So let me start introduction to the trade secret system. Here you see the structure of my presentation. First, we're going to look at the question, what is a trade secret? Then why trade secret is needed. Then we look at the legal protection of trade secret. And I will also stop on the advantages of and challenges of trade secrets in comparison with patent protection. So for now, let me put it very simply. Trade secrets is an information that you don't want the competitors to know about. This is an information that you want to keep secret from others. As you know, the secrecy has been part of businesses, part of trade for thousands of years. One of the famous examples, for example, is secret sericulture, which began in China around 3000 BC. And secrecy over the practice of raising silkworms and making silk allowed the region in China to profit for more than 2000 years. The Chinese kept this secret of silk making secret for so long, and it was really the most jealously guarded secret in history. They were the only ones who knew how to fabricate this luxurious product, and they were able to reap the benefits of the silk trade for more than 2000 of years. Another example, in the 16th century, Sultan of Ottoman Empire, Mustafa, he authorized a person, actually it was Armenian person, to make symbols, orchestral symbols. And that person actually developed the unique way of making symbols, which had a very unique sound. So the formula for making the symbols has been kept secret by the family of this person for generations. And thanks to the secrecy, this Armenian family had 400-year lead in producing the best orchestral symbols. So there's this process of combining copper, tin, and silver is actually still a very closely guarded family secret. And the symbols produced by this family has a very apparently extraordinary musical quality and tone, which is highly demanded by the orchestra around the world, even nowadays. So, and there are endless number of other examples showing that the most common form of protection used by businesses nowadays is a secrecy. And trade secrets are being widely used by businesses across the economy to protect their know-how and other commercial valuable information. So what are trade secrets? Broadly speaking, trade secrets is actually any confidential business information that provides an enterprise with a competitive edge. A trade secret may be almost any information that has economic value and provides the holder of the secret with an advantage over the competitors by virtue of its possession. The meaning of the term trade secret is not limited to the so-called crown jewels, and it really covers a very broad range of information held by company as long as the requirements for protection are fulfilled. And we are going to look at these requirements a little bit later. So as I said, a wide variety of information can qualify as trade secret. These include different types of technical and scientific information, such as designs, drawings, architectural plans, blueprints, maps, algorithms, formulas for producing products, and so on. Also, commercial information, which may include consumer lists, business plans, marketing strategies, list of suppliers and clients, consumer profiles, or sales and distribution methods. It may also include various financial information, such as internal cost structure, pricing information, salary and compensation prices, price lists. Trade secrets may be also even a negative information as to what does not work or works less well could also qualify as a trade secrets. For example, dead ends in research, details of failed efforts to remedy problems in the manufacture of certain products, unsuccessful attempts to interest customers in purchasing a product. All this information may also qualify for trade secret protection. And in these slides, you can see well-known examples of trade secrets. I think you all know about these trade secrets. First of all, this is a famous formula for Coca-Cola. This formula has been created in 1886. And the company actually has decided at the time to keep the formula for this drink a secret. And according to a company representative, the original formula is written on a piece of paper and it's stored in a bank vault, and only a small number of people know the formula at any time. Other examples of well-known trade secrets include the recipe for Kentucky Fried Chicken, McDonald's Big Mac, special sauce, and the algorithm used by Google's search engine. So all these companies' competitiveness, it really depends on these important trade secrets. So trade secrets are being used widely by all businesses of all sizes, whether they're big or small. They all use this protection system to protect their know-how and other valuable commercial information. And in fact, actually, latest surveys conducted in the United States and Europe showed that trade secret is a main way how small and medium-sized enterprises protect their business advantage. So why we need a trade secret protection? There are actually various studies showing how trade secrets affect these companies and the economy of these respective countries. A latest study for OECD found that there is a positive relationship between the effectiveness of countries' trade secrets protection and investment in innovation. Stronger trade secret protection was associated with a greater R&D spending, more foreign direct investment, and several other positive economic outcomes. Interestingly, although a trade secret protects confidentiality, it leads to greater openness and collaboration. Because trade secret laws make it safer to companies to collaborate with each other, with others, including suppliers, manufacturers, or co-developers, because the legal protection by trade secrets encourages greater trust among various parties through greater security. So effective trade secret laws lead to greater willingness for companies to cooperate with each other, to cooperate with strangers. In an economy where trade secret protection is ineffective, businesses are more inclined to remain family businesses. They are inclined to stay smaller. However, where the businesses have a backing of the laws by trade secret laws, they are more inclined to scale up, to expand, and to hire new employees and to add new people with new needed skills. Maybe even more important, trade secrets law makes it safer to work with other businesses, even with competitors. Such collaboration are often essential. For example, another business might be better at manufacturing a product or fabricating a certain part that your business is not necessarily good at. So trade secret law supports the division of labor, which is a basis of a modern economy. It's more efficient, it saves money, and it leads to growth and mutual benefit. Just imagine what it would be like if no one could count on the protection on the trade secret law, and they could not be able to enforce this obligation with confidence. Apparently, businesses would hire fewer people, since each new employee would expand the risk of information loss. The cost of enforcing physical security, such as locks, fences, would increase. And perhaps most importantly, many licensing transactions and research collaboration would not happen because there would be nothing to ensure that partners would not run off with a new technology and unfairly compete against its creator. So the general approach in the case of absence of trade secret law would be hoarding of information, keeping the information, and slowing the progress of innovation. So we can really state that trade secret law is a legal regime that protects the relationship of trust. It creates an environment where companies would trust each other and collaborate with each other for the benefit of mankind. So recognizing this importance of trade secrets protection, the legal system of many countries protected confidential information since long time. However, it was with the development of this this international instrument that countries, many countries of the world adopted the laws protecting the trade secrets. So the first main multilateral treaty which provided some guidance with respect to trade secret protection is the Paris Convention for the Protection of Industrial Property. However, the Paris Convention does not mention or define the trade secrets beyond the general obligation for member states to provide protections against unfair competition, which is defined by the convention as any act of competition contrary to honest practices, industrial or commercial matters. Then, as regards to the direct international protection, it was an agreement on trade-related aspects of intellectual property rights, the TRIPS agreements, which is an agreement administered by the World Trade Organization, which specifically expressly required the protection of undisclosed information in Article 39. Specifically, Article 39 of the TRIPS agreement sets minimum standards of protection to provided by each member state with respect to the trade secrets protection. And we are going to look at these standards and requirements in a few minutes. So while the TRIPS agreement provides for requirements on protection, imposes the obligation for member states to protect trade secrets, it does not really prescribe specific details how these laws should be implemented. Therefore, national laws with respect to trade secrets are varied. Some laws protect trade secrets under the unfair competition law, some protect under the tort or contract law or IP law, and there are countries where the trade secrets are protected under specific trade secret law. So let's look at the requirements of the TRIPS agreement more closely. So according to the TRIPS, in order for information to be protected as trade secret, it shall meet the following criteria. First of all, the information must be secret. Secondly, the information must have a commercial value due to the fact that it has been kept secret. And thirdly, the holder of information has to take reasonable steps to keep it secret. So that these are, in essence, three characteristics that qualifies for trade secret protection. It's its secrecy, the value, and measures taken to protect its secrecy. So first requirement, the information must be secret. That means that it should not generally be known or among or readily accessible to persons within the circles that normally deal with this kind of information. It should be noted that absolute secrecy is not required. It's not required. For example, trade secrets can be kept by several parties as long as it's not known to other persons working in the field. The secrecy condition can be met. So test here is really on the accessibility of information by persons working in the field. Further, the second requirement, the information must have commercial value flowing from the fact that it's secret. In other words, it confers, trade secret should confer some economic benefit to the right holder, flowing from the fact that it's not known and therefore cannot be put to use by others. And this economic benefit must derive specifically from the fact that it is not generally known, not just from the value of the information itself. It means that information itself need not necessarily be able to put into practice in valuable way. The fact that competitors may perceive this information as having value and they would spend money to find or develop it would qualify an information as having economic value. In general, it's not easy to determine the exact value of trade secrets. And then elements which are considered in making such assessments are competitive advantage for the owner in using the trade secrets, the cost for an outsider to duplicate the trade secrets, or loss advantages to the trade secret owner resulting from disclosure to the competitors. Third condition that I have mentioned, persons lawfully in control of the information must have taken reasonable steps to keep the information secret. So the owner must exercise reasonable efforts to maintain its secrecy. The owner's mere desire or intention to keep the information secret is not enough to fulfill this requirement. Generally, what is reasonable is determined case by case, and it depends on the industry, it depends on the nature of information, and it depends on the national law. The test here on the quality of measures taken to protect the information. And while this word reasonable, as I said, may depend on the circumstances of each case and industry practices, the following examples are measures to be taken if there is to be a remedy for in case of misappropriation. So basic requirement is that any person to whom the information is disclosed must be under an obligation to maintain the secrecy. So signing confidentiality agreements, making confidential, marking the documents confidential, placing physical and electronic restrictions to access a trade secret information, introducing a systematic monitoring system, and raising awareness of employees are the measures taken to safeguard trade secrets. So the trade secret law will allow businesses to share confidential information with employees and even with the other businesses as long as it makes reasonable efforts to protect it. So that because the trade secrets can be shared under the protected conditions, they are not actually truly secrets as defined by common understanding. What is secret? A secret is usually something known to only a very few people. And as an American statesman, Benjamin Franklin famously said once, a secret known to 3 people is only secret if two of them are dead. is not really applicable in case of trade secrets, because trade secrets can be shared with many, but it must be carefully guarded. And as long as it's shared on the condition of confidence and does not become generally known, trade secret law will prevent it from being disclosed or used without permission. And as I mentioned, in essence, the characteristic qualities of trade secrets are its secrecy, its value, and measures taken to maintain the information secret. And the Bahrain law also defines a trade secret as information which meets the three requirements. Specifically, law number 7/2003 in Article 1 states, it shall be prohibited for every natural or corporate person to disclose information in his possession if it characterized by the following. First, the information is confidential. Confidentiality is therefore fulfilled if the information in its final form or in its specificities neither known nor circulated and is not accessible for those who usually deal with such type of information. Second, if it was of a commercial value due to its confidentiality. And third, if its confidentiality was dependable on the effective measures undertaken by its legal holder to preserve it. So what are the rights of the trade secret holder? In general, trade secret protection confers owners the right to prevent the information lawfully within their control from being disclosed, acquired, or used by others without their consent in a manner contrary to honest commercial practices. While the determination of such practices depend ultimately on the circumstances of each individual case, in general, unfair practices in respect of secret information includes breach of contract, breach of confidence, and inducement to breach. It further includes the use of or disclosure of a trade secret by a third party who knew or was grossly negligent in failing to know that such practices were involved in acquisition of the confidential information. I should also note that trade secrets are not absolute. There are circumstances when the disclosure of trade secret is not considered unlawful. First of all, under some laws, if a competitor independently discovers a trade secret without stealing it, or is able to learn the trade secret through the reverse engineering of the relevant product, such conduct does not infringe the trade secret holder's rights. Trade secrets are also not considered to be misappropriated if the alleged infringer has disclosed the relevant trade secrets to an administrative authority or judicial organ in order to safeguard public interest and stop criminal acts. The trade secrets, it's also not possible to rely on trade secret law if it concerns the right of freedom of expression and information in some countries. Fourth, trade secret protection is also generally dismissed in most of the countries where the acquisition or use or disclosure of trade secrets was carried out for revealing misconduct, wrongdoing, or illegal activity. There are also some laws put limitation on the use of non-compete agreements. When the employees leave the work and they go for other work, they should be able to use the skills they learned in the previous employment for their own benefits. So the idea is that trade secret law should not restrict the free movement of workers and mobility and prevent the mobility of workers. So the law of Bahrain also provides exception from trade secrets protection. Specifically, there is a provision which states that it shall not be regarded a violation of this law if the competent administrative authority undertakes measures to disclose such information due to the compelling need to protect the public, or if the said competent authorities undertook the necessary measures to guarantee suspension of unfair commercial usage of such information. What are the advantages and challenges of trade secrets, especially in comparison with patent protection? I hope you're all familiar what a patent protection is. So with respect to the patent protection, trade secrets can be both. It can be alternative to patent protection, but it also can be complementary to patent protection. So when it can be alternative? It can be alternative, for example, when we have a trade secret information, technical information, which may qualify for trade secret protection. Then the holder of the trade secret protection, the trade secret has to decide whether he should protect that information under trade secret law, or whether he should protect that technical information by the patent system. It can also be alternative when the information does not qualify for patent protection, because the patent protection has a very rigorous requirements, and not all the trade secret information may qualify for patent protection. In that case, the holder of that information may rely on trade secret protection. So when the patent system can be complementary to trade secrets, first of all, before the filing patent application and during the patent prosecution process, until the patent application is published, the information has to be kept secret. This is a very important information. This is an important requirement if the patent applicant really wants, would like to obtain the patent information. If he discloses his information during the patent prosecution or before filing, he may not able to obtain the patent, because that information would be in public domain, and it would not meet the novelty requirement of the patent law. The trade secrets law and patent law can be also complementary with respect to the, for example, technology, with respect to the different features of the technology. For example, some features of the same technology can be protected by patent system, especially if there is a more likelihood that that feature could be reverse engineered or independently discovered by third party. Then it's better to protect on the patent system. And other information which is could be protected by the trade secret law. So the trade secret and patent protection, they can work alternatively to each other, or they can work complementarily. When the trade secret information qualifies for the patent protection, then the applicant or the holder has to decide whether he should protect his information by the trade secrets or patent law. And therefore, he should be well familiar with advantages of the trade secret protection compared to the patent protection, and disadvantages of such protection, of trade secret protection. Advantages of trade secret protection. First of all, it involves no registration cost. Secondly, trade secret protection is not limited in time. It may be protected indefinitely as long as it kept secret and not disclosed to others. The trade secrets protection is immediately effective. It's not like with respect to patents when the applicant has to wait the grant of a patent to be able to enforce his rights. And most importantly, trade secret protection does not require the disclosure. As you may know, disclosure of the essential features of the invention is actually most important requirement in the patent law. Actually, patents are granted in return for the disclosure, and that requirement do not exist in the, of course, for trade secret protection. It's actually opposite here. You have to keep it secret in order to be able to obtain protection. So what is the disadvantage of trade secret protection in comparison to the patents? As I already mentioned, reverse engineering and independent disclosure. The holder of the information is not protected against somebody, for example, discovering that secret independently. He may even be able to obtain patent protection for that for that information, because the trade secrets has never been published and it cannot act as a prior art. Therefore, the third person who independently discovered that information cannot even obtain a patent protection. Second disadvantage of trade secret protection is that protection is only effective against improper acquisition and use or disclosure of confidential information. It's not like patent-like rights, when the patentee is able to prevent anybody from making, using, importing, and other commercial actions with respect to the patented invention. What is also I should mention is that in case of trade secrets, trade secrets actually it's more difficult to enforce than patent. Often it's quite difficult to prove the violation of a trade secrets, and the level of protection granted to trade secrets actually varies from one country to another. But the protection with respect to trade secrets are generally considered to be weak, particularly when compared with patent protection. And due to the secret nature of trade secrets, selling or licensing of trade secrets is more difficult in case of trade secrets than patents. And this slide actually summarizes what I have just told you with respect to the advantages and disadvantages of trade secret protection in comparison with patent protection. And I would like to finish my slides by stating that in an information economy that we live in now, knowledge, data, information, and consequently trade secrets are becoming more and more important, making countries and governments to update their laws with respect to trade secrets and adopt new laws with respect to trade secrets to help companies to protect their valuable commercial information. And this is really must in an age of globalization where people are more mobile. They're no longer, let's say, loyal to one factory or business. They move a lot, and there's more threat that the trade secret misappropriation learned in previous work would be revealed. There are more collaborative business relationship, and there are more commercial disputes before foreign courts, which also actually threat for misappropriation. And also technological development, they act as a double-edged sword. We are having more technologies developing, and trade secrets holders, they have a better technological shields to protect their trade secret information. But on the other hand, they also more vulnerable to misappropriation. These technological developments also make it for other people, for third parties, to make it easier for them to steal the trade secret information. By one click of a mouse, they can actually misappropriate the important information. So this is all with respect to the introduction to trade secret. If you have any question, I would be happy to respond. Thank you very much for your attention. Yes, please don't hesitate to pose me questions. You can also write in our chat if you wish. So, thank you.
Yes, thank you, Ms. Ida, for keeping the time and for sharing with us a historical background on trade secrets and sharing the difference between trade secrets and patents. I thank you so much. And now we will move, according to our schedule, to our next speaker, Mr. Emmanuel Goje. He will shed light on a practical approach on how to protect and manage trade secrets of your business. Mr. Emmanuel, over to you.
Many thanks. Many thanks for the invitation to Bahrain Chamber of Commerce and to WIPO. Good morning, everyone. One practical question. Is it for me to display the slides on my screen, or do you put it for me?
You can display it and share your screen.
Right, okay. So I just need probably one minute just to put them back on my screen and to make sure that, okay, if you give me, okay, here we go. I think, no, this is one, I just need 1 second. I'm sorry for that, but I won't be long. If you give me here, and so that we have everything here on the right screen. So 1 minute here. Yeah. Good. And now I have to share, and to share, it should be now here. Share my screen and the share. Can you have it on the screen?
Yes, go ahead, Mr. Emmanuel.
Okay, thank you. Sorry for the slight delay. Right. So, and thanks to Aida for the introduction. And I think what I've been asked to present for this 30 minutes is the way you get the protection for your business, which in my view implies two things. It's how you protect your own trade secrets, but also how you make sure that you don't infringe trade secrets of others. So I think it's the two sides of the same coin in a way, yeah. And that's why I just want to, I will be brief on the first part, because I think that Aida has already touched upon the framework, and I want to see then what you have to do in terms of, or what can be done, I should say, in terms of internal and external measures, and also some of the best practices. And this is based probably on some of the experience that we've seen over the time. Well, this is based personally on 25 years of practice as a lawyer, admitted both in France and in England and Wales. So my perspective will probably be rather a European one, but nevertheless, what this slide shows is the fact that we are in a way under the umbrella, so to say, of the TRIPS agreement. And from there derives a number of the laws or of the applicable regulations that can be found in a number of countries around the world. And this is probably particularly true for when it comes to the applicable laws in Europe, which are under the umbrella, so to say, of a directive, which was adopted in 2016, and which you can see on the screen, the Directive on the Protection of Undisclosed Know-how and Business Information, so trade secrets, and this against their unlawful acquisition, use, and disclosure. And obviously, you would find a number of different references, whether that's in the US with the US Act of 2016, whether that's in, and I won't list all of them, and probably, and sorry for my ignorance for the current situation in Bahrain, but I presume that you also have your own set of rules. I think I had a quick look when preparing here. But my focus here will probably be more on the terms of the European Directive. And when it comes to the European Directive, I think that similar to the TRIPS agreements, you find three main criteria. You need to have a secret information. And that's defined actually in, and whether we look at the TRIPS agreement or the directive, as being a secret information, which is the information which is not generally known, or it says readily accessible to persons who are familiar with this type of information. And well, you could say, well, this is rather vague, or at least what does it mean exactly? And I think it's true, it's fair to say that this is very much linked to the actual business, to the actual industry we are addressing. And as a result, what might be secrets in one industry or in relation to one company may be regarded differently in other industries. So the threshold might not be the same everywhere. And this is what I want probably today to emphasize, as opposed to what we have probably with, let's say, patent law, for example, which in a way is more, only to some extent, black and white. And we'll come back to this, obviously. The second element is the commercial value that derives from this secrecy in a way. And what it means is that the purpose of considering trade secret protection is not per se attracting trade secret protection, but it's also that because you have this secret information, or because the information is secret, it has or has to have commercial value. In other words, if there is no commercial value deriving from this secrecy, then the information may not attract the trade secret protection. And third, but not least, what is listed here on the screen as the reasonable steps. And this is key, and probably one of the most practical elements, one of the most practical aspects that we have to consider. You have to make sure that you have, as a holder of the information, you have taken all reasonable measures in order to keep the information secret. And we'll see what it means, or what it may mean. But clearly, if no sufficient reasonable steps have been taken, then you will not be able to claim trade secret protection. So this is for the sake of reminder in a way, because I think that that was already touched upon by Aida to some extent. I just wanted to be back to the, if you want to have a look at the Trade Secret Directive, you will find, for example, all these different definitions under Article 2 of the directive, where you have what trade secret means, the secrecy, the commercial value, and the reasonable step I've just mentioned. So back to my slides. I think another important element that obviously we have to bear in mind, and also from a practical perspective, is the fact that as opposed to patent law, where in summary, if I'm a patent holder, it means that I filed a patent application, I've been granted a patent, and in a way, this gives me a sort of monopoly, and this should prevent third parties to implement my technology, or at least my patents, without my consent. And this also does prevent them from developing independently a sort of same technology, because if they do so, and if it falls within the scope of my patent, I can prevent them from implementing their technology. We're probably in a different sort of mindset with trade secret. The trade secret as such does not bring a sort of direct monopoly to the trade secret holder. Or in other words, the trade secret protection does not prevent third parties from developing independently their own technology in a way which could be similar or identical to your own trade secrets, but providing they do it independently. So why do I say that? Just because, for the sake of reminder, we have to bear in mind that it works in a way differently. Just want to make sure that my pace in speaking here is fine, also for translators. If I'm too fast, please let me know so that translation can can work according to what needs to be done. Right. Let's turn on to the internal and external measures of our trade secret protection. One, we're addressing the way company want to put in place a sort of policy in order to make sure that their trade secrets are well protected. We have to consider a number of different stakeholders. And this is certainly not a sort of limitative or exhaustive presentation here. But what I want to raise here is the fact that you have, as a company, a number of different players who you have to watch out in a way, or to supervise and make sure that they will be the one who will comply with the policy, and who will make sure that, you remember, we say 3 criteria, one of them being the reasonable steps. So you want to make sure that all of them comply with, comply with the reasonable steps, reasonable measures. So that will be true first for, obviously, all your employees. You want to be sure that employees comply with trade secrets, that they will protect your own trade secrets, but also that they won't steal, or with whether that's on purpose or not, that they won't steal trade secret of others. You want to make sure that also others working within the company, whether they are subcontractors, trainees, consultants, will also be bound by the processes, by the policy you've put in place. You've obviously to make sure that all sorts of external, whether they are mere visitors in a way, whether they are service providers, that they will also be bound by the policy you put in place. And you want to be sure that they won't be a threat also by possibly stealing trade secrets, for example, when they leave the company. So that's the sort of map that we have when we try to address and put in place internal and external measures. And I think that most importantly, we have to remind ourselves that the threats does not necessarily come from outside the company, but the threat may, in a way, come from inside the company. And don't misunderstand me. The purpose of my talk here is not to say that we should be paranoid. We have to trust our people. We have to trust our teams. But in the meantime, we have to make sure that the process that are in place do work according to the requirement that we've seen in order to be able to claim them a valid protection for your trade secrets. And again, namely, always back to the same basic principle, making sure that you've defined and implemented all relevant measures, all relevant steps, reasonable steps that have to be implemented in order to be able to attract trade secrets. Right. So the first thing is certainly to identify what we are talking about. That's what I call here the tracking the trade secrets. It's all about identifying, defining, and classifying the trade secrets to be protected. How do you do that? Well, and really here it comes to what I was saying earlier. It very much depends on the sort of industry you're in, and also on the sort of size and organization, size of the company, and the type of organization you're in. Is your company a pharma company? Is your company an IT company? Is your company handling documents physically? Is your company only sort of online company? So you obviously need to adapt the measures and the processes depending on the sort of business you're in. It also, the way you organize it also will depend on the type of geographical footprint you have, and whether your company is a centralized or rather decentralized company. And this has to be defined and organized by bringing together a number of different stakeholders when it comes to designing the processes. Probably the legal department, but certainly not only. The IT department, certainly. But also sometimes, obviously, sort of security in the sense of the one who are protecting physically the premises of the company, making sure that you have relevant processes when it comes to badging, who has access to which rooms, to which environment. All of these elements have to be identified and then defined so that you can then come to a sort of classification. What sort of classification? Here again, it varies. If I'm thinking about some clients or even companies in which I've been working myself, very often what we would see is a sort of 3 or 4 levels. And I'm sure, for example, WIPO has also some classification. And in order to have the sort of, level where information can be shared outside the company, then second level where information cannot be shared outside the company, but can be shared inside the company. The sort of third level where information can be shared only with a number of defined groups, and probably a more stringent level, sort of high, very high, confidential, which is only to the addressee, i.e. defines a nominative circle of people. And this has to be clear for everyone, because again, you want to make sure that when it will come to defending your trade secrets, you will be able to explain, whether that's in the course of a litigation, whether that's in front of a court, whether that's in the course of an arbitration. You will need and you will have to explain what are your processes in a way, so that you can convince the fact that, yes, you've put in place all the reasonable steps, which are one of the 3 criteria for attracting trade secret protections. Right. What does it mean practically? Does it mean, for example, that you have to mark documents and material as confidential in order to attract confidentiality protection? To be honest, you can take the 2 positions, yes or no, in a way. Yes, indeed, it is probably good to identify that documents are confidential. But the risk, in my view, that if you put the confidentiality marking as one of the criteria for attracting confidentiality, it means that either people may mark everything as being confidential, in which case my fear is that you dilute the value in a way of the confidentiality, or possibly that people forget sometimes to mark something as confidential, whereas it should have been marked as confidential. If as a sort of stupid example, what I want to say here is a train ticket a confidential element? Because you would stamp it with a confidential marking, would it all of a sudden attract some sort of confidentiality? And the answer is probably no. So you may prefer to identify the confidentiality when it comes to, for example, non-disclosure agreement, not only by marking documents, but rather by the sort of group of information, saying that the type of information that will be exchanged between the parties will be confidential when it relates to that sort of information, that sort of technology. A third recommendation is the importance of, or to the extent possible also, to register the dissemination and disclosure of the trade secrets. What I want to say here is to track down. It's important to know exactly who has been able to access and to share some of the confidential information. That's, in my view, key, and that's where we face sometimes difficulties, is the risk of dilution of your trade secrets. The more people have access to the trade secrets, the more important the risk is, obviously, that there's a dilution of the trade secrets, because there's a risk of leakage, but also because then you don't know exactly who has access, who's able, who has had the information, and who's able to use that information. A fourth element here is the non-competition and confidentiality provision in employment agreements. And that's true also for a service provider, for trainees, when they, for example, operate on site. And obviously, non-competition is not confidentiality as such, but sometimes will give more efficiency into the confidentiality. So that, again, there are two different things. But if on top of confidentiality, you make sure that there is a non-competition provision that will give more, not only value, but your confidentiality, as a matter of fact, will be more effective. And I don't want to expand on this, because this is more also this touch upon employment law. So this may vary from one country to another. In some countries, the non-competition provision is sometimes difficult to enforce unless it is paid, for example, unless there's a clear consideration, but nevertheless, keep that in mind. So, and another element which is not here on the slide, but which in my view is key, is the fact that you also want to implement measures which are realistic, which will work. Don't try to enforce too much. It's better to implement things which will work, which people will take ownership of, so that they will effectively implement them. When it comes to be too complex, the risk is that it might be the ideal plan, but that it may not effectively be implemented. Right, let's turn on to the next slide. Some of the elements which here on the slide are also practical aspect of what should be done at the different stage when it comes to employees, for example. And here, what do we have? The entry and exit briefing and interviews for the employees. It's important when an employee joins the company, but also when he leaves the company, to address the issues of trade secrets. So what do we mean here? It's when an employee joins the company, make sure that he's aware, and that's probably also in writing, that he should not come with trade secrets or information from his previous employer. And that you as a new employer, you don't want him obviously to come and use any of his previous information that he had with his in the course of his former employment, but also make sure that he is informed that and contractually bound by a commitment that he or she will not use the information that could be trade secret of others. That's key, so that again, in respect of the reasonable step that you will have to explain if at some point you have to either defend yourself or claim your own trade secret protection, you will have to show that you've put in place all the reasonable steps that are required. And this will be one of them. And the same applies when employees will leave the company or are leaving the company. Here again, make sure that, and to the extent possible, obviously, that you have a sort of interview where you can sort out the information that that employee has been able to access during the course of his employment, and make sure that also he has a clear of the fact that all the information which should remain confidential do remain confidential. And sorry, I just need to, I have an issue here with, yeah, here we go. And this is certainly a more and more important element in the course of the life of the company, so from an HR perspective. Another element when it comes to employees is obviously the training and education programs, whether they are online, whether they are in real or physical training. This is key that the employees achieve and complete these programs, and also on a regular basis, so that they are aware, and for two reasons. The first one, that you may one day have to explain that you've put in place these programs, but more importantly, to make it effective, so that your employees are informed, but more than being informed, that they can have the sort of level of awareness that you expect them to have. Building access control, securities cameras, I think I've raised that already, but this is also one practical element. And the same would apply to the sort of more virtual security, which is obviously as important, if not even more. The IT security measures, whether that's password, VPN networks, encryptions, and the likes. And to make sure that your systems are, I would say, bulletproof, or at least as much as possible, because we all know that complete bulletproof systems is very, very difficult to have. So that's the sort of practical element that we want to make sure that you put in place. So let me speed up a bit, because I'm close to the end of the time I've been allocated. Yeah, interaction about the outside, whether that's suppliers, customer, competitors, partners, in a way that the same of similar reasoning. And this is where you want, with your outside counterparties, make sure that you secure the exchange of information by non-disclosure agreements. Accept what you can achieve. What we want to say here is the same sort of approach as the one I was explaining. You have to be realistic. You should, to the extent possible, not accept a commitment that you cannot achieve, you cannot reach. So make sure that what you accept, what you sign in a way, will be something that your organization will be able to reach, to meet. I will leave aside the MTA, which is probably more in the sort of life science field. In R&D, research and development, and as well as collaboration agreements, make sure obviously that all sort of confidentiality aspect is well covered. And the same applies with licensing agreement, obviously. Make sure that all the information that you share, whether you as a licensor or you as a licensee, will be covered by the by an NDA. I'll leave this.
Mr. Emmanuel.
I'm coming.
Yes, we have almost 1 minute.
I will finish it in 1 minute.
Yes.
I'm finishing it now. Okay.
All right, perfect.
I just want to show you the best practices here. Bear in mind what we have here. It's really about identifying and interview management with the employees. We say that. Make sure you have good risk assessments, and then develop and implement your policy within the organization. Okay, so that's in a way a summary of what I've said earlier. Identify, perform, mark, and manage. This is really what we want to convey as a message. You will find here some other elements, but most important is what we've already addressed. And training, education, interviews, IT system we've raised. We're now at the end of the presentation. Thank you so much for your attention.
Thank you so much, Mr. Emmanuel, and thank you for sticking to the time. I would like to also thank you for your insightful presentation and shedding light on measures to protect trade secrets, internal and external measures and practices, or actually best practices in trade, in maintaining trade secrets. Let me reiterate on something that you mentioned about keeping trade secrets. Can we say there is a correlation between maintaining trade secrets and loyalty, the loyalty of the employees of the company to the organization? Can you share your reflection on that?
I think in a way that's an important point, as you were saying. And that would be probably from the employment law perspective, which is key, yes, which probably vary from one country to another. But in a number of countries, that's in a way consubstantial to the employment agreement in a way. The point is that what we are trying to do also by emphasizing the sort of additional contractual commitments with a specific commitment from the employees in respect to trade secrets is to make sure that not only you rely on the sort of indeed loyalty commitments, but that you have something more, which when it comes to making sure that you can prove that you have put in place all the reasonable measures which are required from a trade secret law perspective, that you can have this additional layer, which in my view will put you in a better position rather than only, if I can put it that way, relying on the sort of general principle of loyalty, but which indeed should include the sort of also not breaching trade secrets, whether of your company or of others.
Thank you. Thank you so much, Mr. Emmanuel. Now we will move to our third topic. It's misappropriation of trade secrets, the rights of trade secret owner and possible remedies. So we have with us Ms. Nina. Are you here with us, Ms. Nina?
افتح لها المايك. Okay.
Ms. Nina, go ahead.
Hello. Yeah, I'm sorry. I had problems with unmuting me. Apparently, you needed to deblock it. But now
we can hear you.
And we can. Okay, great. Thank you a lot. And before I start, I just saw a question for Emmanuel. So since he's still here, you might also wish to answer this in the chat box. I think we have 1 minute left, so maybe might be a good option. And I will start already with my. No, Emmanuel, do you want to answer this now?
Right. Okay. Well, thank you, Nina. I'll try to be brief here. And protection of training and education programs, online courses. Is that the question here? Yeah, I think what I wanted to emphasize here is the importance of also. I mean, it's all about the same target in a way. You want to make sure that all the measures you put in place are effective, and that they will work. and that all the stakeholders, all the players within the company or organization will not only be contractually bound, but also will understand and implement. And that's where the training and education programs come into place. So my point was not so much to protect the training and education program as such, but to make sure that through education and training programs, all participants in a group, in an organization, will effectively implement the policy around the trade secret protection.
Okay, great. Then should I start if it's okay? I will share my
Yes,
screen.
go ahead. Yes, go ahead, Ms. Nina.
Okay, do you see my presentation?
Yes, we can see it.
Thank you very much. And thank you for the introduction from Aida and Emmanuel. I think it's a great basis, and I will try to, well, refer to some of the points already mentioned when I come to my topic, misappropriation of trade secrets and the rights of trade secrets owners and possible remedies. So I also want to give you the structure of the presentation first. As I already said, I will have a short introduction where I will make a short recap of what we already heard. And this should be only a revision thanks to our previous speakers. And then afterwards, I will give you an overview of the rights of trade secret owners. And here I also, as Aida did, and Emmanuel will take an international perspective, but I tried to, since I think Bahrain law is the most interesting for you, I will also try to give you some references to your trade secret law. And the same for the third part of my presentation. Here we will have a look at trade secret enforcement and possible remedies. And also there I will start from the TRIPS agreement and also have a quick look at Bahrain law. However, I have to say, since I'm not a lawyer or in your country, of course, the interpretation issue needs to be addressed by courts or by the national expert, but I can give you an overview and the international perspective. And then we have question and answer session at the end. And please really do not hesitate to ask me questions, to write them in the chat. And I will also share my email address as Aida and Emmanuel did. So if there comes something up later, it's also possible to ask me later. So as said, I have a short recap, the requirements for information to be protected as a trade secret. Well, we have already heard that the TRIPS agreement gives a minimum standard of protection, and it is also implemented, as Aida said, in Bahrain law in Article 1 of trade secret law. This is law number 7 of 2003 and law number 12 of 2006. And here the first requirement is that the information must be confidential. And confidentiality, or as it's also in the international level, secrecy is, as we have also already heard, is not that it's not known to anyone, but it must not be easily accessible to people that normally deal with this kind of information. And the second, and due to this confidentiality, it has a certain value for the company. So if you remember the example Aida shared, the Coca-Cola recipe, it would be much less valuable, or maybe not at all valuable, if people know how to get the taste of Coca-Cola. If competitors knew this, that would be a problem for Coca-Cola, of course, and therefore this confidentiality of the recipe is the reason for the value of the information. And then the last step, Emmanuel also referred to in the end of his presentation, especially that there needs to be reasonable steps taken in order to get a trade secret, but also, so it's part of the definition of a trade secret, but it's also, of course, a protection measure to make sure that your trade secret is not shared, disclosed without your consent. So it's a bit of a double perspective. On the one hand, it's already needed to be a trade secret, and on the other hand, of course, you also want to do it to protect from misappropriation as such. So let's quickly also have a look at this effective measures or reasonable steps. In the English version of your Bahrain law, it's called effective measures, and reasonable steps, that would be the TRIPS wording. So I refer to both. And as I said, it's part of the definition of a trade secret, and it's also prevention of misappropriation. So this double idea of the reasonable steps. And reasonable steps are, as Manuel also said in AIDA, it's identification first. What is a trade secret? Because you need to know where are your trade secrets in order to be able to protect them. And then the education of employees in whatever measures that fit your business, such as online courses also, or just briefings. If there are trade secrets involved, it should be known among the employees. And also maybe also to say this is a need to know basis. So employees who do not necessarily need to know the trade secret, they shouldn't know it in a way. So that's also one measure that was, I think, already mentioned, of course. And then the application of physical or technological restrictions to access the trade secret, limitation monitoring public access to buildings that house trade secret, and these can all be measures to protect it. And of course, marking documents containing trade secrets, and the already mentioned agreements that you sign, such as non-disclosure agreements. So now we come to part 2, the rights of trade secrets owner. And here, again, I give it the international and the Bahrain law as far as I can. So the rights of trade secret owners and third licensed parties are also mentioned in Article 3, Section 2 of Law 2003 on trade secrets, amended by Law number 12 of 2006. In the following, I will refer to this as a Bahrain trade secret law, just to make it a bit simpler. And here it said that trade secret owner or third licensed parties can disclose the trade secrets to others. So trade secrets are recognized as intellectual property, and also intellectual property you can dispose, of course, as an owner or third licensed party. And this with consideration or without consideration. So this I wanted to mention, even though it's something that is not strictly related to misappropriation. This is just a right that a trade secret owner or third licensed party has according to Article 3.2. And now we have a look on the rights of trade secret misappropriation. And here also Article 3 states that a trade secret owner can prohibit trade secret misappropriation. And this, if it's through any act contradictory to lawful commercial practices. So, of course, this is not easy. What is an act contradictory to lawful commercial practices? As also in the TRIPS agreement, it's also an interpretation issue. And here I want to have a quick look what is implemented in Bahrain law. Here, Article 4 gives us some examples of what is an act contradictory to lawful commercial practices. This can be a breach of contract. This is, I think, quite sure. If you breach a contract, it's not a lawful commercial practice. And a disclosure or inducement of disclosure against, of course, the will of the trade secret owner. So if you know this is the trade secret and you disclose it, or you tell someone else to disclose it, this is mentioned as an act contradictory to lawful commercial practice in Article 4. And acquisition, if it's from places where the information is reserved in any illegal manner. And here also the law names fraud, espionage, robbing, bribery, or other of these ways to get the information or reserve it in a way. So if you acquire from these places, this is also considered, again, against lawful commercial practices. And also the bad faith acquisition from another person. So if the law says, or the English translation of the law says, know or is capable of knowing. So some third person is capable of knowing that this information was obtained through any act prescribed above. So any act against contradictory lawful commercial practices. Then it's considered a bad faith acquisition, and also considered such an act contradictory to lawful commercial practices. So it gives already some interpretation. And just for you to know, a TRIPS agreement footnote 10 has a similar wording and gives also similar ideas than the Bahrain law. Mentions also the breach of contract, breach of confidence, or inducement to breach. So Article 4 implements these footnote 10 anyway, just for you to have also an overview. So as Aida already mentioned, there are exceptions of trade secret misappropriation. And Bahrain, I think Aida also mentioned this already, Article 1 Bahrain Trade Secret Law gives us such an exception. So it's not considered a misappropriation, for example, if the competent administrative authority undertakes measures to disclose such information due to a compelling need to protect the public. And again, I'm not an expert, but what I can imagine, a public need in general is often referred to if there's a public health, or this is really something very important to society. So in this way, competent administrative authority is able to disclose a trade secret. And also the same applies for the way it needs to guarantee suspension of unfair commercial users of such information. So it's just good to have in mind that misappropriation has also some exceptions. And also it's something that was already mentioned, I think, that trade secret owners have not like patent owners and other IP owners, they're not the rights are limited in a way. So a trade secret owner generally cannot prevent the use of the same technical commercial information if acquired or developed independently. This was already referred to as reverse engineering. So in general, if someone is independently discovering what is the secret behind it, so if, for example, I drink Coca-Cola and against all others before me, I understand what is the recipe, then this might not be considered as a trade secret violation because I discovered it independently. And again, third-party acquisition in good faith is often not, or generally not, cannot be prevented. And others from independently patenting the trade secrets is also something that you have to keep in mind. So if you have a trade secret and someone else is patenting your trade secret without misappropriation, so discovering it independently, you have no defensive protection against this, since a trade secret is not considered prior art. Just as a revision, prior art is in general something that is known to the public already, and when the patent is applied to. Of course, this is not no universal definition, so it depends on the countries, but in general, something that is already known to the public, such as a patent, for example, would be considered prior art and would give you some kind of defensive protection. So this is not the case for trade secrets. And now we will have also a look at trade secret enforcement and possible remedies of trade secret owners. And here again, I will try to give you an overview of the international perspective and also have a look at the Bahrain trade secret law. So on the international level, as mentioned, the TRIPS agreement of the WTO is the relevant or the most relevant agreement for trade secrets. And here there's also some provisions on enforcement. And the one is Article 44 of the TRIPS agreement, which gives us some provision of injunction, and Article 45, which gives us something on our provision to with regard to damages. And according to Article 44, the judicial authority shall have the authority to order a party to desist from an infringement. And this is meant as injunction, as I'm sure we will already know, but just to have in mind, it just means that you need to stop the infringement. And this is in Article 44. And Article 45 gives us also states that the judicial authorities shall have the authority to order the infringer to pay the right holder damages which are adequate to compensate for the injury the right holder has suffered because of an infringement of the person's intellectual property. And in the TRIPS agreement, trade secrets are also considered intellectual property. So this applies to trade secrets. And so this is also a very important provision, I would say, so that you have a damage claim on the international level. This, again, gives no obligation for WTO members to authorize courts to grant injunctive relief or damages against good faith third parties. So these parties, they are not capable of knowing that they acquire a trade secret from the person who violated it. And then provisional measures are very important in trade secret enforcement, I would say, and also generally in IP enforcement. And Article 50 in the TRIPS agreement gives us the relevant conditions. On the international level, the judicial authorities shall have the authority to order prompt and effective provisional measures to prevent an infringement, and also to preserve relevant evidence. And here, of course, it depends on the respective case, but often it's really the court will see whether it is so needed that it should be granted in order to preserve evidence or prevent something. So there must be some evidence already on this infringement that will happen or maybe already happened. And also interesting, especially in trade secrets, is that there are ex parte provisional measures. So where appropriate, in particular where it's likely to cause irreparable harm or demonstrable risk of evidence being destroyed, the potential infringer will not be informed before the measure taken. So this is also, in a way, it's a very hard, strict measure because the other party will not be heard before it happens. And often in the national laws, there are provisions that are saying that immediately after the verdict, the party needs to be heard, and of course can also appeal this verdict. And often there are also in national laws provisions showing that you need to the right holder who wants this provisional measure also needs to give a bank guarantee for potential damages caused to the provisional measure if later on the court, by having time to review everything, feels or states that it was not the right measure, it was contradictory to law. So this is something that the trade secret holder should also have in mind. If someone wants to apply for a provisional measure, it should be, there needs to be some evidence, and you should also be rather sure that there is something, because if you accuse someone and someone will maybe unlawfully have some restrictions in the industry and will stop the production, for example, and there's a huge damage, then if afterwards the court will say, oh, this provisional measure was against law, then you will need to pay in several national law provisions for this damage. So this is something to have in mind. If there's an ex parte provisional measure, also the potential infringer will have some security afterwards, because it's such a strict measure, and he will not be heard before. And yes, this is also maybe interesting to mention. According to the TRIPS agreement, which gives minimum standards, there's no obligation to provide criminal measures or border measures for trade secret enforcement. However, as we will see later on, national laws, criminal measures can be present, since TRIPS is only a minimum standard. So now maybe the more interesting point for you is trade secret enforcement according to Bahrain trade secret law. And here, Article 6 gives us provisional measures in case of infringement or to avoid infringement. So if you remember the already mentioned TRIPS agreement, here Article 6 implements these provisional measures in Bahrain law. And let us just have a look what it's saying. So it's including as provisional measures the detailed description of the product on safeguard evidence, cautionary seizure, which is quite a strict measure also, quite a good measure for the trade secret holder, injunction. So this was what I meant with stopping the infringement, and ex parte proceedings are possible. And here we have, again, as I said, we have to keep in mind, and this in Article 6 mentioned this also, that evidence is needed. So the right owner needs to provide evidence that he is the trade secret owner, and evidence that there is an infringement or potential infringement. So this is also something you need to keep in mind if you want to have a good trade secret management strategy, that you, in case of a misappropriation, if you want a provisional measure, you need to have evidence that you're the right owner and there is some infringement or a risk of infringement. And here, what I referred to before, it's implemented also in Bahrain law. So the bank guarantee is mentioned in Article 6 for possible unlawful damage due to the verdict. So the competent judge can order that the trade secret owner gives a bank guarantee in case there might be unlawful damage due to the verdict. So in case that after the measure was taken, the court revises the case in substance and sees that that the measure was against law and there has not been a trade secret infringement, and then the alleged infringer has some security with this bank guarantee that he will also get a certain damage compensation.
Ms. Nina,
yes.
We have 1 minute left for your slot.
Oh, I'm sorry. It's
yes.
Thank you for this. Then I will continue a bit more quicker.
Yes,
so, and there's a petition against the order possible, of course. And please have also in mind, this Article 6 states that there's a term for a lawsuit regarding the substance afterwards. I think it was 15 days. So this is also my last slide, so we're in time. Article 7, just for you to have in mind, gives a criminal procedure. So imprisonment and or fine can be ordered. For the first offense, it's 3 months to 1 year, and 500 to 2,000 Bahraini dinars. And in repeat offense, you see that it gets a bit more intense, and you will have up to 4,000 Bahraini dinars, and also the possible imprisonment is stricter. And also there's no prejudice of harsher penalty. And let me now quickly summarize. You need to have evidence that you're the right owner, and misappropriation should be gathered. And there are acts that are generally known as contradictory to lawful commercial practices, breach of contract, if you disclose or induce to disclose against the rights holder's consent, and if you acquire from parties that you know or you're capable of knowing that they did it harm the trade secret beforehand. And trade secret enforcement, according to TRIPS, gives precautionary measures, injunctive relief, damage claim, and criminal procedures are possible. And I've already shown you a bit how they are implemented in the Bahrain law. And yes, if there's a trade secret appropriation, a misappropriation, I would always recommend to ask advice and trust the respective national expert. So thank you very much. And sorry, if you have questions, please, I would be available also now. And if not, please just write them in the chat or write them to me as an email. Thank you very much.
Thank you, Nina, for the very comprehensive presentation. Do we have any questions from the participants? I don't see any questions in the chat, but if we have a raised hand or something before we move to the next topic. No questions? Okay, it seems we don't have questions for now. If you want to ask a question, you can leave it at the end also. But now we will move to the next topic with our speaker, back again to Mr. Emmanuel. He will talk now about a practical approach, actually. What are the possible actions that trade secret owners can take in the case of trade secret misappropriation? So back to you, Mr. Emmanuel.
Thank you. Thank you so much for the transition and the kind introduction. And thanks also to Nina for the presentation, which is really the sort of underlying explanations to what we're trying to address now with the sort of practical examples. And I think, Nina, in a way, you've stressed a number of elements which I probably wanted to not to address really, but just to bear in mind. And so here again, I think we've already in the past presentation, whether that's you, Nina, or myself, or Ada, stressed the fact that there are different sources, but really under the umbrella of the TRIPS agreement. The point is, and that was already presented by Nina, what can we do in a way? So the first element of my previous speech was, in a way, what are we talking about, and how do we make sure that we put ourselves in the best position in order to be able to claim trade secret protection, and similarly to make sure that we do not touch upon or infringe the trade secrets of others. And here the point is now to see what are the risks in a way, what sort of sanction can we claim, or what sort of sanction we may risk in relation to trade secret misappropriation. And it's true that rather than infringement, usually the texts refer to misappropriation. You will probably hear me sometime refer to some sort of infringement. It's true that the notion of infringement probably relates more to sort of more traditional IP rights, such as patents or trademarks. So here probably the important elements, which and without repeating too much what was said by our previous speaker, the three main points are: the first one is around stopping, in a way, the unlawful use and the further disclosure of trade secrets which have been misappropriated. That's all about the injunction that as a trade secret owner, you may seek and obtain. But that's probably not sufficient, because once the trade secret has been disclosed or misappropriated by a third party, you will also want to make sure that all the products which may have been manufactured, commercialized, distributed, may be removed from the market, which in itself does raise also an additional element of complexity. I mean, here in terms of bringing the evidence of the relation between, in a way, the product and the trade secrets. How do you prove, in a way, that the product has been obtained by the, for example, implementation of a trade secret which protects a specific, for example, process for producing a product? So the point, probably from a practical perspective, will be the one of the evidence of again, implementing the trade secrets so that it results into a product or a good. But the third element is also, and very often that's actually what is being discussed in front of courts, is the actual damages that you may obtain. And that's really the sort of compensation aspect for them or against the misappropriation of the trade secret. So that's basically the sort of measure that can be obtained, whether that's on the merits, whether that's on a provisional basis. Now, I think that Nina made clear the fact that there are a number of things which a trade secret owner cannot prevent. Whether, for example, that's the fact that you may not prevent reverse engineering unless contractually you've obtained the commitments of a third party that he will undertake not to proceed with reverse engineering. Another one is the fact that if a third party can prove that he or she has developed independently a sort of same trade secrets, then the trade secret owner will not be able to prevent that third party to implement the same trade secrets, so to say. Obviously, the situation is rather unlikely, but it shows the difference between the trade secrets protection and, as I was saying earlier, the patent protection. Another element that we find in a number of applicable laws is also various exceptions, whether it comes to, for example, whistleblowers, whether it comes to freedom of expression, in which case there is no remedy, but because in a way these are exceptions. So I don't think we should look at them from a remedy protection perspective, but more that they are situations which are outside, in a way, the scope of what a trade secret owner may have as possible actions and remedies. So let's now illustrate with some examples. And the way I want to convey the message is also to highlight the sort of risk that one can face when it comes to trade secret misappropriation. And what we'll see now is some case law that a number of them come from the US, but also one or two others that we've picked up from Europe. The first one you will see is a case which involves a US company and a Chinese company. This is Motorola and Itera Communication, a Chinese company. And there have been decisions back in 2020, and the last one is from October 2020, so rather recent in a way, And you will see that we have, in a way, huge figures, I would say, because we can see here, you can see it on the slides. So the first decision was back in February 2020. And here, and that was with the Court of Illinois, the jury, and that's linked to the US systems, where jury will decide also on these sort of cases, granted Motorola with over $300 million, so nearly $350 million as damages, and also, in addition, above $400 million for punitive damages. And that was based on trade secret misappropriation. And you will read here the fact that here it was saying that one can be convicted of attempted trade secret theft if one believes the information to be a trade secret, regardless of whether the information actually constituted a trade secret. It is the intent of the alleged theft that is judged. That's a quote from the judgment. And in a way, I want to come back to the factual element here. And you remember what I was saying about employees going from one company to another. And here we had so the two companies. And in 2017, the Motorola alleged that Itera had recruited 3 of Motorola senior engineer, and they say, well, Motorola say that these employees did steal confidential documents and information, including source code from Motorola, and that they used them to build and to design competing digital mobile radio products, which were then sold by Itera. Actually, here in the case, interesting that Itera apparently did not deny that the engineers in question had stolen these documents and the source code, and that Itera remain in possession of documents containing Motorola trade secrets. But they try to downplay the significance of these elements in the development of Itera's technology. So the point was, in a way, that here there was some sort of acceptance of the fact that some elements were moved in a way from Motorola to Itera and through these engineers. And here, one of the point was, because obviously you can see the amount, which is very high, so that there's been a dispute also regarding the level of damages. And actually, in October 2020, the court then overruled Itera's motion for new trial concerning the amount of damages. Now, what we don't know in this case, at least I'm not aware of that, is whether the court has ruled on Motorola's request for a permanent injunction. And I don't think that we have a final judgment for the time being. But what do we want to illustrate through this case? Because again, the topic for this presentation here is the possible action that owners can take in case of misappropriation. You can see clearly here an illustration of the sort of action that here one trade secret owner, Motorola, has taken against another company, one of his competitors, on the basis of the fact that some of their trade secrets, documents, source code, had been stolen and used by Itera. So the element at stake were not so much against the employee, and there might have been also actions against the employee per se, but the point was more that Itera accepted in a way, and whether that's willingly or not, accepted the information from these employees, which they should have not, and also didn't deny the fact that they used these information. What they tried to do was to reduce, in a way, the importance of that information, of these source codes, and the final product that they developed. So you can see that given the amount at stake, this is clearly a situation where there is a clear incentive, obviously, to comply with strict compliance regarding trade secret protection. And we can see that here, judges, courts, jury can be rather severe when it comes to indemnification in relation to trade secret misappropriation. Shall we go for another illustration? And maybe here with another one which involves now another sort of multinational company, L'Oréal, initially a French company, but which obviously plays in different countries, including in the US. And interesting was the fact that at the beginning of the relationship with L'Oréal and Liquid and Olaplex, which we can see on the screen, we understand that at some point they had some sort of business discussion. L'Oréal had even considered to acquire Liquids and or Olaplex. And ultimately here, they've been claim brought by these two companies against L'Oréal for trade secret misappropriation. That was for sort of hair coloring products. And what you can see in a way is that when it comes to even hair coloring products, the figures can be pretty high, pretty severe here, because we're talking about damages in the amount of $22 million here. And the reason for these damages, according to the court or the jury, was that L'Oréal, they considered that L'Oréal willfully and maliciously, it says, misappropriated the trade secret of Olaplex, and that L'Oréal did infringe or violate the commitment or undertaking that they took in the course of the NDA that they signed, so that L'Oréal signed with Olaplex. So again, this is to highlight and to show the sort of sanctions which can be raised against trade secrets misappropriation. And here I want to read some elements relating to this case here. And according to the court, the facts overwhelmingly support the reasoning here. From the initial meeting to purchase the plaintiff, so L'Oréal wanted to purchase Olaplex, to the copying of the trade secrets of the plaintiff, to the sale and continued sale of the trade secret product. And the court said there is no doubt this behavior was willful and the evidence to support the same. So here, obviously, this is very much based on the facts. And probably here, the amount at stake, when we are talking, remember the earlier case we were discussing was in the range of $300 to $400 million. Here we're lower, but nevertheless, we're talking about $22 million. And here, obviously, this certainly reflect the fact that the court, whether that's the true reality or not, but at least that's what was decided by the courts. What they take into consideration is also the fact that there was a clear understanding from the side of the defendant here on L'Oréal to be, in a way, infringing, misappropriating, or so here again, that they were aware from the beginning up to the end. I was saying earlier, I wanted also to touch upon other probably lower decision or lower in the amount at stake, but nevertheless, which shows a sort of same reasoning when it comes to misappropriation. Now we are turning to a chemical company, and on a case which was decided by a court in Brussels, Belgium. So, and that company is Solvay. Solvay is one of the leading Belgian chemical company, and Solvay have been in discussions with more than discussion actually with an Indian company, namely NPL, which stands, I think, for National Peroxide Limited, and they had even a joint venture with that company until at some point, I think it was back into 2007 or 2010. And a former Solvay employee had been suspected for disclosing information about the company, so Solvay, hydrogen peroxide production and the process relating to it. And they suspected that that employee did disclose the process to NPL, so the Indian company. And following an inspection of the former employee's computer, Solvay was able to provide a number of elements supporting the evidence that would establish the unlawful use of the business secrets by that employee to the benefit of the Indian company. So in a way, what it shows is the importance of bringing evidence. And that's, and I know it's not the topic for today, but that will vary from one jurisdiction to another. So obviously, when we're talking about trade secret misappropriation, one of the practical element or difficulty we're facing very often is that you may be convinced of the misappropriation by a third party, but then how do you support your case? How do you bring evidence of the case? So in countries where obviously discovery is possible, discovery disclosure, like in the US, like in England and Wales, even though it's not exactly the same, it works on the basis of a similar sort of disclosure process. There is this element of the parties have to disclose what relates to the case. In other systems, like most of the continental European systems, the difficulty sometimes is to find that evidence because there is no such sort of disclosure or discovery system. Nevertheless, there are some also pre-action tools which enable some sort of on-site inspection, on the basis of which then, following an order of the court, then the claimant may proceed with inspection on-site of the defendant, on-site of an employee, or here, as the case shows here, for example, investigating the computer of an employee. And that's here the way Solvay had been able to put forward the evidence relating to the transfer of the trade secrets to the Indian company, and as a result, the use by the Indian company. We can see in a way that the amount at stake in terms of fine for infringement is very low, 5,000 euros. You could say, well, that's peanuts. So in a way, there's no incentive not to infringe, so to say. But I think that what is important here is also the fact that an injunction had been granted here, and that, in my view, is also the second learning from this example. The last one, also from Belgium, and this is a decision from a lower court, the Commercial Court of Antwerp, back in May 2019. And here it's a fairly, I'd say, a basic example. which we find, I wouldn't say on a day-to-day basis, but which we as lawyers do deal with on a regular basis, which is here an IT provider. Here his name, Mr. Peter van Doorn. And this IT provider copied large quantities of computer files on simply a USB stick relating to the company's production lines and processes. And here we can see that the court considered that that was actually the case. So this was wrongful misappropriation. And as a result, here held a penalty of 25,000 euros and sanction. That was the sanction against that single person, and also granted an injunction, obviously, to stop the wrongful misappropriation. So here, what I want to show with this example is not so much the figures as such, because they are much, obviously, lower figure than the one we've seen with Motorola in the US or L'Oreal, but more the fact that courts do actually take care and shows also the fact that for the trade secret owner, there is the actual possibility, obviously, not only to have trade secrets, but also to enforce the trade secrets, which is obviously key. And we can see on a day-to-day basis, more and more actions, more and more requests from companies in order to enforce and protect their own trade secrets. But what we can see more and more is also companies which are facing alleged infringements of trade secrets of others. So we can see more and more situations where companies are in trouble in a way against trade secrets of third parties. So it raises concern, and obviously there is an element of strategy in there. I think I was meant to finish at 10:40. I can see it's 10, well, CET 42, so I'm 2 minutes late. Sorry for this. This is the end of my presentation for now. Thank you. Obviously, I'm happy to take questions, and requests in the chat with emails. I think that you will have the presentation, obviously, and you can see the email on the slide. Thank you so much.
Thank you, Mr. Emmanuel, for sharing the case studies and shedding light on the importance of actions and measures that can be taken by the owner of trade secrets. And now, I think with this much we conclude, or do we have another presentation by Mr. Aida and Nina? Would you share with us another case study, or is that all?
No, we have a fifth topic actually, we do together with Emmanuel, and
yes.
We will also encourage all the participants to really, it's like a sum up, a very, very simple cases, I would say. So it's a bit to test you in a good way. So please interact and ask every question, and there are no wrong answers. So please, yeah, feel free to interact in this presentation.
Yes.
Should we directly start?
Yes, go ahead.
Okay, great. So I will share the screen. And start the presentation. And just for you to know, Emmanuel will be unmuted too, and we will discuss, and you can, as I said, also interact. The structure is the following. We have case one. Here we have a look at how to prevent misappropriation for employees, and case two, how to prevent misappropriation, accusation of misappropriation in business relations. And if there is time, we have one third slide, but since Emmanuel also did some, well, very very interesting cases on misappropriation measures. This is also not necessary. Just in case we have time, we will also have a look again to with regard to trade secret enforcement as such. So let us start with case one, and I will give the facts of the case, and then open the floor, and also involve then Emmanuel, who will share with us his insights in the practice from his practice. So we have our company A, who produces a cake with a special confidential recipe. I referred here to the Black Forest cake since I'm from this region, and I don't know if you already ate it. It's very tasty. So this is the cake, and it's a top secret, of course. And until now, only A and his family know the recipe and work in the company. So because the cake is so unique, and the recipe is confidential, everyone likes the cake, the demand steadily increases, and A is now considering to employ bakers, salesperson, logistic experts in order to expand its business. But there's of course a fear. What happens if there are people outside the family that know the recipe? Is there a risk of misappropriation? And this would be fatal for A, because as I said, the cake and its recipe are the basis of his success. So these are the very simple facts of the case. And our question is now, what can A do to protect the recipe from getting unlawfully disclosed? And what especially at the beginning of the employment and during the employment? I think if you have in mind the presentations we had beforehand, you might think of some measures. And the second part of the question is at the end of the employment. So what are specific measures our company A could take to prevent misappropriation at the end of the employment of employees? So I open the floor for you with regard to measures at the beginning of the employment or during the employment. Has anyone an idea he wants to share, he or she wants to share? Until now, I don't have any. Oh, I see something in the chat, but no, this is not relating to this. So if there's no volunteer giving us a possible measure, maybe Emmanuel, what can you share something with us? So I think with regard to the identification in the beginning, maybe.
Yeah. Okay, I can volunteer if you like.
That would be great. And also, everyone who wants to join, please feel free.
Yeah, if I can just add, if participants are more hesitant to talk, maybe this is also due to the language issue, please don't hesitate to leave your opinions on the chat, okay? Thank you.
Yeah, thank you, Aida. Exactly. That's also a very good option.
Indeed, yeah. And I think what you were saying, Nina, in a way is, and indeed, the case is probably a very simple one, prima facie, but that's exactly what you were raising also with the sort of Coca-Cola recipe. The Coca-Cola recipe, I don't know it, but must be a sort of simple one. But the true value of the company certainly lies in the way they manage to keep the secret and the recipe secret. And here, certainly we want to put the emphasis on the angle of employment, and whether that's at the beginning and during the employment or at the end, at the exit of the employee. But also probably one thing that we should mention first is, which is probably obvious, but is also make sure that the recipe itself is well, I was about to say protected, is identified, that the recipe is written somewhere. Or you could say, because that could be an argument, you could say, well, precisely because we don't want it to be to be disclosed. We don't want to write it. So it's from the father to the son to his daughter, and so on, from one generation to another. But that's probably a sort of old-fashioned way to work. Maybe it works. So make sure that the recipe is somewhere in a I don't know whether it's in a bank or somewhere where it's localized, whether it's an IT system, but make sure that also you can track down and say, at that time, this was mine. I, company A, was at the origin of that recipe. This is in a way my ownership. And what we're talking and what we're trying to address is not so much, I know this is my ownership, but also I've made every steps necessary in order to protect my ownership. Because otherwise, if you don't put in place these steps, you lose in a way what you consider to be your ownership, because that will be diluted and that will be in a way the ownership of everyone. And there's no more ownership. There's no more something on which you can claim this ownership. And that's where, coming back to your comment, Nina, what we want to highlight here with the at the beginning of the employment, at the end of the employment. And here certainly and that comes back to identifying the documentation of the trade secrets. And I think we had one or two things in the chat indeed. Let me go back. I think I had seen it. Yeah, adding a clause in the employment is certainly the key starting point in a way. Make sure that whether that's an employee, whether that's a contractor, whether that's a trainee, that they have something clear in their contract. It doesn't need to be pages long, but it needs to be said, to be written, so that there's a clear contractual commitments from the employee toward the employer, that on top of what you were saying earlier as to the loyalty undertaking, which is part of probably most countries in the world of a sort of employment contract, of the commitment from the employee to the employer. But you want to have that sort of provision which makes it clear and that also survive the employment agreement without any room for discussion as to the scope and the extent of this undertaking. So that's, and whether you put it as a separate agreement or whether you put it within the employment agreement, which in my view should be the most simplest way to proceed, this confidentiality, non-disclosure, and also non-compete. Because obviously we shouldn't confuse and mix the two. But one thing is the non-disclosure and confidentiality undertaking. The other one is the non-compete undertaking. They're different perspectives, but nevertheless, the non-compete, as I was saying earlier in the former presentation, is key in order to the extent possible, and again, subject to the various constraints in the light of applicable employment law. But the non-compete provision will also make it effective, this confidentiality and non-disclosure. Because if the employee cannot work then in following his employment with company A, cannot work with a competitor for the same sort of cake, like say, then that will make the confidentiality undertaking more effective, because you minimize the risk that he will be tempted to use that information to the benefit of competitors. Another element I think we had listed is obviously the restricting the access to only to the person who need to know the trade secret. So for example, company A here manufactures cakes. Does the accountant need, does the cleaning lady or cleaning man need to know about the trade secret? The answer is no. So disclose trade secrets of the recipe here of company A only to the one who will need to implement the trade secrets to the recipe. And to check the need to know basis regularly, and to check new employees' obligation with their former employee to get a written statement. What we want to say here is not only make sure that when they come in, they are bound by confidentiality, but also make sure that this doesn't overlap with some of their prior commitment towards former employees. And something we were discussing, I think, Nina, was, and it's here on the slide, the good working environments that will increase loyalty. And that goes back to one of the remarks we had previously as to this general principle of loyalty from the employee to the employer. So that's probably soft skills here, but key. Involve an IP law expert, yes, to the extent possible. But again, there's a lot you can do, companies, organizations can do by just implementing basic, not concept, but measures. And here in the employment agreement, there's a lot company can do, even if they don't have an IP law expert, so that they can put in writing an undertaking of the employee in relation to keeping information confidential. So that's probably what we had in mind when we discussed the case with Nina around the step that here company A could implement when it comes to the beginning of the employment contract and the and during the employment contract.
Yeah, exactly. And I think you also made very clear that it's key that the company has an idea, maybe also beforehand, the employees come, what are their measures, how they can prevent misappropriation, as you said, even if you don't have an internal law expert, if you have some measures in place and maybe have some ideas from general law knowledge, it's as Emmanuel said, it's basically there are some simple measures that can be very helpful, I think, also from your practice, Emmanuel, maybe. So sometimes it's very simple measures that can help, I would say. And I see Tomoko raise the hand, so maybe there is a comment. Please go ahead, you are muted.
Yes, thank you very much, Emmanuel and Nina. I just have a question because you also talk, it is, I think, the 1, 2, 3, 4, 5, 6 bullet point. Check new employees' obligations with former employer and get a written statement. And I think that also relates to the Emmanuel, your case in Motorola case, where there was a former employee of Motorola who brought the trade secret to another company. So in a way, another company hired somebody who brought the trade secret from the former employer. Now, maybe there are, the cases where the company who is hiring the former employee, in this case, Motorola, maybe the Hytera was very bad, and they know that this employee has stolen the secret, but still hiring. But maybe there are cases where the company, I am looking for a new person who is competent in this particular area. Here is somebody who is applying for the job, looks very good, and maybe they don't know that it is a trade secret. Maybe in most cases, they don't know whether it was a trade secret or anything. Now, how could the company who are employing these experts, people who have skills, can control this? And how can they check? What kind of questions they should ask?
Right. Okay. Thank you. Thank you, Tomoko. I think what the underlying point, in a way, is whether good faith, in a way, would be a valid defense for the company. So what you're saying is, in company A, says I have trade secrets, and then you have employees from company A joining company B, and company B wants to make sure that the employees coming from company A will not take with them some sort of information, confidential information, trade secrets, which they would then also used to the benefit of company B. So we are here in a scenario where everybody is in good faith in a way, possibly except the employee in a way. And even the employee will come to that. But then what you say is, what can company B do in order to make sure that there is nothing which an employee from company A will take and use in his new position with company B? Probably the first one, and that's what we try to address here with this bullet point here, the check the new employee's obligation with former employer. But even that, indeed, you can try to put in place everything that is likely to minimize, avoid, and put obligation on the shoulder of the employee. But you will, how can I say, you will never be 100% sure that an employee, a new coming employee, will not, in the back of his new employer, bring some information with a former company. In my view, what the new employer can do is to try to minimize this risk as much as possible. And that certainly goes through a clear undertaking in writing in his employment contract that he is aware of the importance of not infringing, not misappropriating trade secret of others, that he's aware that he shall not take any information from its former employer and so on. And I reckon the situation you're raising is something we can see more and more. I am currently with a case where this is exactly this sort of situation. We are representing a company, coming back to the examples we were raising, a company B, where that company B has been sued by a company A, and that's in relation to an employee that has joined company B. He was joining from, he left company A. Company B has done, in my view, everything that is a sort of good practice, namely having an undertaking on the side of the employee, which clearly say that that employee is aware of the importance of trade secrets, of not infringing trade secret of others, and that he is not allowed to bring any information, whether that's from his former employer or from anywhere else, to the benefit of company B. But nevertheless, in the back of the employer, company B, that employee has used or reused information that were coming from company A. And the point I think that it raises is whether on top of that contractual undertaking, whether company B, because you could say, well, you know, they've signed this, but they didn't mean it in a way. And that they then didn't put in place the relevant IT system, relevant checks, relevant sanctions, so to make sure that not only there's this commitments in writing in the employment agreement, but that company B has on top of this implemented all relevant measures to make sure that that could not happen. But I think that what it shows is how far do you have to go? How far is your obligation? And the problem we face, or company face in a way, is that in most countries, and that would be the case in France, for example, but that is my understanding for a number of other countries, is that the employer remain responsible for what employees would do, whether that's in the back of the employer or not. And it's only in very rare circumstances that the employer can have his liability not raised, because it can be shown that the employee was actually not committing the company. And this is where it comes to the complexity of what we're discussing here. But what is clear is that any step that company B, in our example, would take would certainly maybe not exclude company B liability, but at least minimize the risk in terms of the damages that could be awarded then to company A in our example. I hope I've addressed your comments and questions, Tomoko. Nina, do we want to go to the second part in a way?
Yes, I think if there are no more questions from the other participants, I think we can move to measures at the end of the employment. And I have, or we have listed some, and maybe we can discuss on those lines a bit.
Yeah, and this reflects also what the question of Tomoko in a way, and what we're discussing right now. And here, not only you want to make sure that obviously you don't have new employees who will pollute in a way your company, but also make sure that the one leaving will not be able to take information which would harm your trade secrets position. And as we were listing here, Nina, make sure that you immediately or as soon as possible restrict access to the extent possible and subject to employment law. I think we have to stress this because that may vary from one country to another.
That's true.
Make sure that you can inspect, if need be, emails, logins, all the elements which in a way make sure that the employer has a sufficient understanding as to from the time the employee, for example, has notified his decision to leave the company or the decision of the company to dismiss an employee, to make sure that the employee cannot download a number of information or so on that he would likely then be able to take away from the company. And again, obviously, good practice should be that at the beginning of joining the company or at the time of joining the company, the employee is under an NDA obligation. Review this obligation just to make sure that they are in place. And if not, possibly also on top of the sort of loyalty obligation, make sure that you have a sort of contractual undertaking from the employee to the benefit of the company. That would be the sort of usual recommendation, plus possibly have a sort of exiting interview. Because one thing is what is in writing, but also a sort of exiting interview is a good way to sometime on an informal basis understand what, so is the desk clean? Make sure that you can discuss with the employee, and sometimes through that sort of exiting interview, you get some information which you may not have in writing, and this information then can be part of what you list as to information which should not be taken by the employee outside the company. That would be some of the recommendations.
I think you stressed a very, very good point, which goes also on the lines that on the loyalty that one participant also raised, I think, or what was raised before, that loyalty is one aspect, and also this exiting interview in a good way can also help in this regard. Even if someone exits the company, there can be still some fairness that can help also to prevent misappropriation. I think that's also something that you had in mind, if I correctly understood.
And if I may add also one point, is the fact that it's a matter of balance in a way. And I was saying earlier, the risk is to become paranoid. And obviously we have to address things in terms of priorities. And if we come back to our example here, recipe of company A. So yes, there's a recipe as such, but if we're talking about a baker who will leave the company to join another bakery, you cannot prevent him to continue to work as a baker. What you want to make sure is that he will not touch this recipe and that he will forget, in a way, the recipe as such.
Yeah.
But he will never forget to be a baker and to continue to make pastries or cakes, because that's in essence what he knows to do and that's his knowledge. And you cannot prevent somebody from continuing not only to have the knowledge, but also to perform his work, unless obviously you have a sort of non-compete provision, but that's another one, even though it may be key in terms of enforcing and making sure that the information remain confidential.
Yes, that's a very good point. Thank you. So if there are no questions from the participants, and I think we underlined the main points and main measures. Of course, there may also be additional measures that we would, I think, gave some examples. And so we can move on to case 2. This is okay with everyone? Here in case 2, we have the case scenario, how to prevent misappropriation, accusation of misappropriation, which was already stressed in a way, also with Timothy's question in case 1, in business relations now, not from employees, but in business relations. And here we have the, again, our company A, and they, as I said, demand steadily increased. He also expanded the business, and now he also is thinking about expanding its offer and about maybe having some additional varieties of cakes, desserts, or something like this. And in this regard, he wants to collaborate with his customer B, which is a large food company. And the aim of this collaboration is the invention of a dessert with a similar taste as the cake, but as more suitable for mass production. So expansive of offer with a collaboration with someone that has already experience in this field. And here B suggests now that both companies share relevant recipes. Of course, this will include the recipe of A with regard to the cake, because that's useful for the taste. And in B's sense, there may be some, for example, recipes with regard to how to get a long-lasting recipe or something like this. So this is our case scenario. So again, very simple. And our questions are now, what measures could company A take in order to prevent any misappropriation of its trade secret? So this is again from A's perspective, what can he do in this business collaboration? So if you have any ideas, please don't hesitate to put them in the chat or let us know by just unmuting yourself or raising the hand via the reaction button. Maybe we can otherwise discuss a bit, Emmanuel. Do you have something in mind that is very good for or a good measure for A? Maybe we can discuss the unnecessary disclosure. Can you give us some examples or what we have thought of with regard to this point?
Yeah, thank you, Nina. Yeah, I'm happy to volunteer again. You've pointed one of the important elements, which is in some. So here we are in a situation where, so basically, company A has a process, a knowledge which is specific to a certain product, but needs also the input from another company, company B, in order, in your example, you say, in order to proceed with some sort of mass production. So each company has this sort of specialty, its sort of knowledge in its space. The risk that we can see often in this sort of situation is people to talk too much in a way. And as a result, well, too much and with too many people. So too much means, in a way, disclosing things which are not necessary for the sake of the project. And with too many people, well, with people who are not necessary in relation to the project. So I think that one of the first recommendation is certainly to make sure to identify what is needed, and as a result to exclude what is not needed, what is not necessary. And that's why we've put here on the slide the reject unnecessary disclosure. And you may say, well, that's common sense. That's not really legal. Yes, that's right. But nevertheless, remember again the rationale in the way to address trade secrets is really, yes, it is legal, but it is always around secrecy, commercial value, and reasonable steps. And I think that if you disclose too much, in a way, you're not reasonable. Because reasonable means, in a way, going and dealing with what is necessary. If you disclose unnecessary information, you're outside the reasoning of a sort of reasonable steps, in my view. So that's why this is the first, in a way, element that we have listed here.
Exactly, and as you said, it seems to be common sense, but it's good to have in mind. And in our example, for example, it might be not necessary to share with others than the R&D department of B, for example. So just to go again a good example of the case. But let's maybe talk about the next point. Sorry. Yeah.
No, I was about to say the next one belongs to the first one in a way, or they work together.
Yeah, exactly. So this is the need to know basis we already mentioned several times.
Yeah, and what can be said on top here is, I mean, sometimes it is indeed, there's sometimes some sort of different approach, because company B may be willing to know more, because they would say, well, in order to be smart and clever in the way that me, company B, I can help you in addressing the sort of mass production, I need to know more. So it's probably for both parties to try to find the right balance. And also for company A, not to be frightened to disclose. So I know you can take one and the other position, but this is where certainly, as always, you need to make sure that what you disclose is well protected by a clear NDA, non-disclosure undertaking.
Exactly, and this was also our third point that we wanted to mention. Non-disclosure agreements again are a key point in this book.
And here probably, and then we'll address also, I see something in the chat, but before addressing the question from the chat, the problem I can see with non-disclosure agreements sometimes is either they are too broad or they are too long in terms of duration. And when I say too broad, I think that an efficient non-disclosure agreement should relate to a specific project as much as possible. And here, I think that the scenario you've explained to us here is pretty clear, Nina. Is a scenario where we have a company that has already a know-how, a trade secret, and wants to find a solution to maintain the same quality, but to go for mass production.
Exactly.
And in a way, that should be the frame and nothing else. And the NDA should relate to this. And we should also take the angle from company B, because also company B company B probably has something where they have also their own know-how, their own trade secrets, and that they don't want to disclose too much to company A. Or at least they want that what they do will remain with the frame of making sure or trying to address the concern of company A in order to go for mass production. But company B may help other companies in other fields, also in the bakery maybe, and also for going to mass production, because this is what they know. So I think that in that respect, the scope of the non-disclosure agreement is also very important, so that you can limit and frame it clearly.
Yeah, exactly. I think, as you said, a well-drafted non-disclosure agreement was probably a key matter.
Yeah.
There is one question in the chat I've seen. So the question is, what if the misappropriation claim was a recipe of a local business and it was leaked through the social media and it was widely used all over the world on YouTube? So what do you say
which
about
I like it. I like it because I think that that's something we we see more often than it should be.
Yeah.
I think that one of the problem I can see probably is what the sort of protection that the local company has taken in order to protect their recipe or whatever. So first, whether it may attract the trade secret protection. And then, sadly, I should say, what is the possibility for that company to go and sue elsewhere or locally? And then I think it comes to more complexity around sort of private international law as to whether you may sue in one country and try to get sanctions, injunction, and damages, which may relate also to the misappropriation all over the world. And here in your example, the point is, or could possibly be, can we identify who has misappropriated, who has put the information on YouTube, and to what extent that will cause a damage to company A, who was the local owner of the recipe. So in theory, I think that there is something to be done. But the problem that you may face is identify clearly whether you can sue that, well, whether practically speaking, you will be able to sue that person. And if this is the case, I think, yes, then you should be in a position to potentially identify the sort of damage that has been caused to company A. But then it raises a number of additional questions. If company A operates only locally, possibly you could say that company A would have never been able to operate outside the local region or country where they operate, had never intended to do so. So what is the actual damage, and so on. But yes, that would be probably the sort of reasoning or approach I would take in order to try to address and tackle this sort of position.
Great, thank you. This question clearly shows that even in a very simple fact base, there are so many questions involved, especially when it comes to internet and other countries that are maybe involved. So I see that we are close to our time limit. So I just want to go to our last slide here with regard to phase 2. Here, the question was, what measures could company A take to prevent that B later accuses company A of trade secret misappropriation? So this was already stressed with regard to the employees by Timothy's question beforehand, but now in the business, together like a business relation, what can you do? Do you have some practical tips? I think we have put something already, so maybe we can describe what we thought about.
Yeah, yes, thank you, Nina. I think what we discussed here as an element of response was, in a way, when we say take note that describe the process, the method, is to make sure that there is no confusion as to what has been exchanged between companies, because here the risk would be for company A so we have here B would accuse company A of trade secret misappropriation of company B, and the risk would be that A works with B, but for whatever reason they decide that it doesn't work, or that they're not happy to work together. So company A will want to say, well, I want to go for mass production, but actually company B is probably not the right partner, and I may want to work differently, or I realize I can do that myself, but differently. So what you want to make sure, if you're on the side of company A, is that you can limit and describe precisely what has been exchanged, what has been disclosed by company B, and so that you can prove later on that you're not using and that there's no interference with information which was coming from company B. That's probably what we want to say here when we say describe the process, the method precisely, so that there's no uncertainty as to what are we talking about.
Yeah, exactly. So if you are not sure whether it will work out, you should have evidence in place in case that you will decide to search for another business partner. So some written notes and maybe also the use of timestamps if you have the possibility in your company. That can often help, I think. I don't know, Emmanuel, if you have some practical.
Yes, I think it's self-explanatory in a way, and what I want to say here is it's all about tracking down the who has done what at what time, and it can be done by different ways. Sometimes it can only be by exchanging emails internally, which will show in a way who has done what at what time within the company, who has received what, so that obviously you get the who, you get the when, and you get the what. So it's all about documenting, which is also your last point here on the slide, and keep records of that, so that when and if need be, you can bring them on the table, evidence your case, evidence the fact that there's no interference. A number of the cases that we can see in, we've seen Motorola, L'Oreal, I could have named a number of other ones, are around some sort of, I'm surprised in a way, but we know why, but to see a number of situations where actually, if the parties had better defined what they were working with, the who, the what, the when, I think that a number of cases would not be on the table, would not come to court.
Yeah, I imagine. Thank you. So I think we already are a bit over time. I don't know, or are we still in time? I think in any case, we don't have time for our third case, but it was only a backup. So, and it's on the slide. So if people want to have a look at it, everything is on the slide and you will get some relevant ideas. And it's, as I said, Manuel already gave us some misappropriation cases in his in topic 4 in his presentation. And let me just also mention one thing. After our closing session, we also would like to invite you, as we already said with our separate invite, and it's mentioned in the program, to our virtual get-together. We would really love to be in Bahrain, or to invite you to Switzerland in our, so to see you in person, so to say. So we try to combine both worlds here on the park, and it would be really nice to see all of you in this virtual environment. I think the chat, Aida put it already in the chat box. And so it's another platform. You would need to log out and close your camera settings on Zoom, so that you can go in the other platform, and it's very easy, and we can have chats. And of course, it's just if you have time and you want to. So all participants or speakers that are available, please join us on Wondermeet. So this is all from my side, and thank you very much, Emmanuel, for your insights in topic 5, and also for the participants that have asked questions. Thank you.
Yes, Nina and Emmanuel, I thank you so much for sharing insights and talking about these case studies. And let me reiterate on a couple of things that you mentioned: the importance of signing a non-disclosure item, and also conducting exiting interviews. I think this will add a human element to it, and ensuring that people feel comfortable and confident not to disclose, not only by signing contracts. And let me also reiterate on another important item that you mentioned, and it has to do with restricting access to trade secrets. Definitely, I couldn't agree more with you on restricting access in the first place, and the scope of the non-disclosure agreement. I thank you so much for taking the time and discussing these very important and practical case studies. And now maybe we have final remarks from Ms. Tomoko. Would you like to add a final remark? Yes?
Under participation, Father.
Yes, please, Ms. Tomoko.
Yes. Do you hear me?
Yes.
Very good. So, ladies and gentlemen, I think it has been a very intensive day, and you might have start feeling dizzy with too much information on the trade secrets. But let me follow our good tradition of concluding workshops with a short closing remark. But before doing so, I have a very important announcement. You're going to receive an evaluation form from probably Bahrain Chamber. So please fill in this form to provide your feedbacks and comments on this workshop. It's very important for us to assess and improve our activities for future. So please also, in order to better understand your needs, don't hesitate to add comments or your needs and expectations for any future activities and our cooperation. Now, coming back to my closing remark. So looking back today's discussions, I think this workshop has highlighted the fact that the trade secrets are very relevant to all kinds of businesses, big or small. And it's not only for technology companies, but it also applies to all kinds of commerce. So it is, I think, is a very important topic for all forms of successful businesses. The second thing is maybe that this workshop also made it clear that the trade secret protection does not require filing and registration of trade secrets like patents, but it means that the holder of the trade secret information needs to manage the information properly. So there needs to be a kind of management involved. So and this is a challenge because the businesses need to know what to do with those information, how to mitigate the risk, and how to use the trade secret system. So in that light, I would like to congratulate the Bahrain Chamber and the Directorate of Foreign Trade and IPO Bahrain for their foresight to organize this workshop that focuses on trade secret issues. And on behalf of WIPO, I thank both organizations, Bahrain Chamber and the Directorate of Foreign Trade and IP, for their cooperation throughout the preparation of the workshop, hosting the Zoom platform, organizing interpreters for non-Arabic speakers, and moderating the session today, and so on and so forth. I know that in organizing this kind of event, usually there are so many people working behind the scene, and I thank the contributions of all of them. And it was not possible to come to the end of this workshop without their support. I also would like to express appreciation to the speakers, my colleagues, and in particular, thanks to Mr. Emmanuel Gauger for his excellent presentation and sharing really his practical insight with us. I also would like to note my thanks to the participants coming to this workshop, sharing your time, and also asking questions. You are basically the main actors of the day, and I hope you all find something useful that you can take home with. And lastly and not least, we would like to thank the interpreters for bridging the language gap and for making the conversations happen with your tireless work and your expertise. Now, trade secret laws are usually very short and there's not many provisions, but as you learned today, they can cover so many wide-ranging issues, and it's a challenge. And today's workshop is a start of the long journey. And we hope that you had a great one-day excursion with us. And we look forward to continue walking through with you this journey of trade secret and explore many more exciting things. So next time, we really hope that we can meet in person and have a cup of tea together and chat face to face.
Yes.
Thank you so much, Ms. Tomoko. You said it all. I was going to thank everybody and thank everyone working behind the scenes, as you said. So let me reiterate on what you said. I would like to personally extend the thanks of the Bahrain Chamber to everyone who joined us today and to our partners from the Ministry of Industry, Commerce and Tourism, and to you from WIPO. Let me highlight Mr. Waleed, you yourself, Ms. Tomoko, Mr. Emmanuel, and Aida and Nina. Thank you so much for sharing your presentations and your expertise. Let me remind our participants today that they can always go back to our YouTube channel to watch this webinar. It is available. And also let me remind them to complete the evaluation form, which will be sent to them by email. As we said earlier, the presentations that our speakers shared today will be available on the website, the official website of the Bahrain Chamber. That's www.bahrainChamber.bh. So with this much, we conclude today's webinar. I thank you once again, and hopefully we'll see you in future